When Congress says it has authorized billions of dollars, the headline number does not settle whether an agency can spend any of it. The decisive language may be buried in the enacted text. If a law says a sum is authorized to be appropriated, it generally gives permission or guidance for a later funding decision. It ordinarily does not itself provide budget authority. Different language can produce a different result. An authorizing law may directly provide money if it actually makes an appropriation or otherwise supplies budget authority. So the useful question is not simply, how much did Congress authorize? It is, did the statute merely establish policy and contemplate future funding, or did enacted language actually make funds available? That distinction separates a policy commitment from legal authority to incur financial obligations. The starting rule comes from Article 1, Section 9, Clause 7 of the Constitution. Money may not be drawn from the Treasury except pursuant to an appropriation made by law. That makes appropriations central to federal spending, but it does not mean every law mentioning a dollar amount is an appropriation. Federal law adds a textual safeguard. A statute may be construed to make an appropriation only if it specifically states that an appropriation is made. An authorization amount can therefore communicate the scale Congress permits or anticipates without opening the Treasury by itself. This is why two laws with the same headline number may have different budget consequences. One may set program rules and authorize a later appropriation. Another may contain language that directly provides budget authority. The operative statutory text, not the press release, bill label, or announced total, controls the analysis. An authorization law ordinarily creates or continues an agency, program, activity, eligibility rule, or other policy. It can define who qualifies, what services may be offered, which agency is responsible, and how long the authority lasts. It may also state an amount that is authorized to be appropriated. That amount can guide or limit a later discretionary appropriation, but the phrase generally anticipates another legislative step. In the familiar two-step model, authorizing committees write the program's substantive framework, while appropriators later decide whether and how much discretionary budget authority to supply. Calling the authorized amount money delivered collapses those separate decisions. At the same time, authorization is not meaningless. It can establish enforceable duties and legal architecture even before discretionary funding arrives. The accurate description is therefore specific. Congress may have approved a policy framework and a potential funding level without yet making that funding available for obligation. The authorization versus appropriation distinction is a strong general rule, not an absolute label-based test. Some authorizing laws provide budget authority directly. If enacted language actually makes an appropriation or otherwise makes funds available, an agency may receive legal authority to incur obligations without waiting for a separate annual Appropriations Act. The Congressional Budget Office classifies funding provided directly by an authorization act as mandatory spending. That means a measure can combine policy design with direct financing. Conversely, a document called an authorization act is not automatically unfunded, just as a prominent dollar figure is not automatically spendable. Federal law requires specific language before a statute is construed to make an appropriation. The safest approach is textual. Locate the provision governing funding. Identify whether it merely authorizes future appropriations or directly provides budget authority, and note the purpose, amount, period of availability, and any conditions written into the law, even when Congress has provided an appropriation. Another distinction matters. Budget authority is the legal authority to incur financial obligations. An obligation is a binding commitment by the federal government, such as entering a contract or approving another commitment that will require payment. An outlay generally comes later, when the government disburses money to settle that obligation. These stages can occur at different times. An authorization level may be larger than the amount appropriated. The agency may then obligate only part of the available budget authority during a given period. Actual outlays may follow as work is performed or payments become due. Therefore, an enacted appropriation is not proof that every authorized or appropriated dollar has already reached recipients. Clear public accounting should distinguish four concepts: the authorized amount, appropriated budget authority, obligations entered into, and outlays actually disbursed. The strongest case for separating authorization and appropriation is institutional division of labor. Subject matter committees can design programs, set eligibility standards, establish legal duties, and revisit performance. Appropriators can compare resource demands across the government and decide what can be funded in a particular fiscal year. In principle, that creates two opportunities for scrutiny, one focused on what government should do, and another focused on resources and competing priorities. It also preserves flexibility because congressional procedures include exceptions and can sometimes be waived. But the system can obscure accountability when officials celebrate an authorization figure without explaining that a later appropriation is still required. The center-left case for active government should include an equally strong case for transparent budgeting. Public commitments are easier to evaluate when lawmakers and journalists state whether Congress designed a program, supplied usable budget authority, entered obligations, or completed payments. Congressional rules encourage the authorization appropriation sequence, but the House and Senate do not use identical rules. For general appropriations bills, House Rule 21 generally makes an appropriation for an expenditure not previously authorized by law vulnerable to a point of order. A point of order can block or remove language when properly raised, but House points of order may also be waived. Senate Rule 16 is narrower. It principally restricts certain floor amendments that add or increase appropriations, while recognizing exceptions for amendments directed by the Appropriations Committee, the relevant authorizing committee, or an estimate submitted in accordance with law. The Senate has no general standing rule prohibition against funding a program solely because it lacks a current authorization. These are rules governing how each chamber considers legislation. They should not be restated as a universal constitutional or statutory rule that every valid appropriation must first have a separate, current authorization. An expired authorization of appropriations does not automatically terminate a program or nullify later funding. In a decision issued April 29, 1992, GAO concluded that there is no general constitutional or statutory requirement for a specific authorization act to precede an appropriation. GAO also concluded that an agency may use an explicit appropriation for a program whose authorization of appropriations has expired, including funding supplied through an annual appropriation or a continuing resolution. But this does not create unlimited authority. The appropriation and the underlying program law should be read together. Substantive restrictions in the program law ordinarily continue to govern, and an appropriation will not continue a program when enacted text shows congressional intent to terminate it. Expired authorization is therefore an important oversight status, but it is not, by itself, a complete answer to whether current budget authority exists or may lawfully be used. CBO's July 10, 2025 report illustrates how often appropriations and current authorizations can diverge. It identified fiscal year 2025 appropriations totaling $500 billion associated with 457 authorizations of appropriations that had expired before that fiscal year began. That is a historical snapshot, not a finding that the appropriations were invalid. It is also not a definitive procedural ruling. CBO expressly cautioned that matching appropriations to expired authorizations involved uncertainty and that its exercise was not definitive for applying House or Senate rules. The figures nevertheless show why shorthand can mislead. An expired authorization may coexist with enacted funding, while the existence of an old authorization level does not prove that an equal amount was appropriated or spent. The number is best used to illuminate the complexity of congressional practice, not to erase the legal distinctions that the report itself preserves. To evaluate a claim that Congress provided money, inspect three things. First, read the enacted funding clause. Does it say funds are merely authorized to be appropriated, or does it specifically make an appropriation or otherwise provide budget authority? Second, check for a later appropriations law or continuing resolution covering the same purpose and period. Third, read the underlying program law for substantive limits, eligibility rules, expiration provisions, or language showing an intent to terminate the program. Then keep the accounting stages separate: authorized amount, appropriated budget authority, obligations, and actual outlays. This test avoids two opposite errors. It prevents an authorization ceiling from being described as cash already delivered, and it prevents an expired authorization from being treated as an automatic funding ban despite a later enacted appropriation. Procedural flexibility can be legitimate. Democratic accountability still requires plain language about exactly what Congress enacted and what the government has actually paid.